Hi, I'm Greg Artim. I'm the managing attorney at Artim Law, and today we're going to talk about how to respond to a credit card lawsuit in Pennsylvania. The first thing that we need to discuss is that there are two different court systems in Pennsylvania. The first is the District Justice Court, and these are for claims that are for $12,000 or less. And the second court system is the Court of Common Pleas. Much more formal court system, and we're going to get into that in a minute. So the first court system that we want to talk about is District Justice Court. It's a very informal procedure there. Many district justices will allow you to simply call them up and say, I want to defend the case. Some of them require you to submit what's called an intent to defend. An intent to defend is a simple one-sentence statement that says, I want to defend this case. And that's literally all that's required at the district justice level. You don't have to file an answer. You don't have to file objections, and there's no discovery. There's no interrogatories or anything of that sort that you would use at the district justice level. So the second court system that we want to talk about in a little more detail is called the Court of Common Pleas. And in the Court of Common Pleas, you have two choices when you file a response to a lawsuit. The first choice is to file what's called an answer. And an answer is a generalized list of defenses, of denials, and what are called affirmative defenses. And these would be things like lack of standing, statute of limitations, payment, identity theft. Answer is a response that we file on very few cases. What we typically choose to do in the Court of Common Pleas when we have a credit card lawsuit is to file what are called preliminary objections. And these are, by definition, a preliminary motion that we would file with the court. And this is typically based upon the fact that debt collection lawsuits are defective when they are initially filed. These guys file these lawsuits in bulk. So they file what we call a bare bones lawsuit. There's typically not a lot of information, and sometimes there's zero information contained in these lawsuits. So what the preliminary objections are is a statement to the court that says, hey judge, this thing is defective, please make them fix it. And the defects that we typically see are lack of documentation. If it's a debt buyer case, they have to provide a copy of a contract showing that they bought your account. Because it's a credit card claim, they have to provide a copy of the terms and conditions for the account. And then they also have to produce a large amount of monthly statements showing the charges from zero up to the amount that they sued you for. And when these documents are not attached to the lawsuit, while you can file an answer, the more proper response, at least initially, is to file these objections. And again, this is a way to try and force the other side to show their hand right off the get-go, because if they can't provide these very basic documents at the beginning of their lawsuit, they don't deserve to move forward to the hearing stage. And so my preferred response on most cases in the Court of Common Pleas is to file preliminary objections. Again, going back to the answer, we do file those on very few cases, but it's often on a case where the value of the claim is fairly small. Maybe if you have a $1,000 case or a $1,500 case or something, in that ballpark, we might just file an answer as a cost-saving measure for you to get ourselves into a position where we can protect your rights and just jump into a hearing and beat them that way. So these are the responses that we have at the district justice level and the Court of Common Pleas. I'm Greg Artim. We do offer a free 15-minute consultation to anybody in Pennsylvania who has a credit card issue. Please give us a call.